Hello, I'm Jaspreet on this side. I'm company secretary by profession. Usually I search for many things on Google and at times I search for things on YouTube. So while driving, I prefer listening to some professional updates and legal updates. And so I thought of creating a content for myself and obviously other co-professionals. So the intent of this series is that we go through Companies Act Sarans. This last mile referencer for companies law for Companies Act 2013 is created by ICAI, and the best part is that I love this because it contains everything in graphical form. Each page is very uh, good graphically. So I appreciate the Institute of Chartered Accountants of India for creating this book. And as I was going through this book, I wanted to create this video for myself that I can refer to while driving and for co-professionals who can also benefit of this book. So let us start. I appreciate all the creators. And now we proceed with the first part of the book, Companies Act 2013 Preliminary. So first it starts with title, Companies Act 2013. It extends to whole of India. Commencement Section 1 came into force at once and the remaining provisions on different dates through notifications. So all the sections were not notified on the same day. This we can take as a key takeaway. Then application, whom this Companies Act applies to. So the Companies Act applies to all the companies. Then we have insurance companies, banking companies. Why insurance and banking companies are considered separate? Because there are separate rules and regulations for these companies, and they will comply primarily with their rules and regulations and secondarily with the Companies Act. Then companies producing or supplying electricity, companies regulated by special act, entities as notified by central government. Next is brief introduction about company and its type. So what is company? Company means a company incorporated under this act or under any previous company law. Section 2, subsection 20. So I will skip to refer to sections and subsections which you can see on the screen. A company is an incorporated association which is an artificial person created by law having a separate entity with a perpetual succession. So what we found is that it has a perpetual succession, that is, it continues whether its directors, members continue or not. Then it is a separate legal entity, means it is recognized by law as independent of its directors and members. It has its own identity. It is an artificial person. It do not live, breathe like human beings, but it is a person in the eyes of law. And it is incorporated. So we have to get it incorporated by following the procedure. Next is types of companies on the basis of liability. Now, companies can be divided into whether the members of the company have their liability limited, or it can be limited by guarantee, or it can be unlimited company. So, first basic which we everyday encounter is a company limited by shares. At the end of the name, we read words limited or private limited. Liability of the members of a company is limited by its memorandum of association to the amount, if any, unpaid on the shares held by them. So there are, when we incorporate a company, there are subscribers to memorandum, means the first shareholders, and they subscribe to certain shares. And a memorandum contain the authorized paid up capital plus objects of the company plus various. It is a constitutional document, so it describes what is a company incorporated for what purpose and what is the limit of liability of its members. And if it is a new company, then there will be disclosure of subscribers, that is number of shares subscribed by them, at the time of incorporation. So these are basics contained in memorandum. State where company is incorporated is also mentioned in memorandum. So liability of the members of a company is limited by its memorandum of association to the amount, if any, unpaid on the shares held by them. So we have heard that there can be first call, second call, and a company either, suppose a share is of rupees 10 per share. So either rupees 10 completely is paid by a member, or a part payment is done and a part amount is due. So that is a possibility under Companies Act. Next is companies limited by guarantee. So companies limited by guarantee, section 2 subsection 21, liability of its member is limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. So in the memorandum, a amount is provided that if the company goes into winding up, then this much amount will be contributed by each member towards the liabilities of the company. So these are termed as companies limited by guarantee. Personally, I have not encountered any company limited by guarantee in my career so far. Members cannot be called upon to contribute beyond that stipulated sum. So members, the amount is specified, members are clear that they will not be required to pay beyond what is described in the memorandum. Unlimited company. This is the third type of company. Unlimited company means no limit on the liability of members. So members are equally liable to the extent the company is liable. So if the company goes into winding up, then whatsoever are the liabilities that the company has to pay, the creditors the company has to pay, are to be paid by the members. The liability ceases when he ceases to be a member. Now, if a member ceases to be a member, means they do not remain a member of the company, then their liability also ceases. So means at the time of winding up, whosoever are the members, they will remain liable to the unlimited extent. This also I have not encountered practically in my career so far. Now on the basis of members, now again what we are talking is types of companies. First one was on the basis of liability, limited, guaranteed, or unlimited. Now is on the basis of members. So on the basis of members, these can be of one person company, it can be private company, it can be public company. So let's go with one person company, section 2 subsection 62. Now, in one person company is that directors can be more than one, but a member is only one, means a shareholder is only one. So only one person as member. This is one requirement of one person company. Minimum paid up capital, it has no limit prescribed for minimum paid up capital, means that a member has to, there is no requirement, no restriction on the member to subscribe to minimum paid up capital. Then the memorandum of association shall indicate the name of the other person nominee who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. So if the subscriber, the only member, dies, then who will be the nominee? Who will take over? Who will be the next person? So that has to be indicated in the memorandum itself. Then next is a member of OPC, one person company, may at any time change the name of nominee by giving notice to the company, and the company shall intimate the same to the registrar. So member may at any time change the name of the nominee, means nominee is not fixed, nominee can be changed. How a nominee can be changed? By giving a notice to the company. And at the same time, when the company receives a notice for change of nominee, then what will company do? Company will intimate the registrar of companies simultaneously. Next is no person shall be eligible to incorporate more than one OPC. So if a person is member in one OPC, then the same person cannot incorporate another OPC. He cannot have multiple companies by being their only shareholder. Next is no minor shall become member of the OPC. No minor. So since minor is not capable of contracting, so minor cannot be a member, but can minor be a nominee? So that we can consider. Such company cannot be incorporated or converted into a company under Section 8 of the Act. So Section 8 companies are special purpose companies incorporated for some social non-profit cause or educational purpose. They are prescribed purposes for which Section 8 companies can be incorporated. And Section 8 companies are not required to write at the end of their name words limited or private limited. Now, OPC cannot be incorporated as a Section 8 company. OPC cannot be converted into a Section 8 company, though it may be converted to private or public company in certain cases. So OPC conversion is possible to private company. OPC conversion is possible for conversion into public company, but it is not possible to be converted into Section 8 company. Next is such company cannot carry out NBFC activities including investment in securities of any body corporate. So now question is, can one person company hold shares of any other company? So can it invest in shares of other companies? So it appears that it cannot carry on NBFC activities and it cannot invest in securities of other body corporate. Here, a member can be a sole member and director. So the same member can be sole member and the same member can be director. Next, these are on the basis of members. First, we learned on the basis of liability, limited liability, then guaranteed and limited liability, and now we are understanding types of companies on the basis of members. So first one was one per person company, next is private company, and then next is public company. Next is private company, section 2, subsection 68. No minimum paid up capital requirement. So for private company, there is no minimum paid up capital requirement. Means the members of the private company need not subscribe to any shares. Then minimum number of members. There are two minimum number of members required in a private company, except if private company is an OPC, where it will be one. Next is maximum number of members. So the maximum number of members in a private company can be up to 200. If a private company wants to exceed this limit of 200, then it will require to first convert to public company. Otherwise, normally a private company can have members from 2 to 200. Now this 200 excludes present employee cum members and erstwhile employee cum members. So if shares are offered to employees and a person is employee and member, then that will not be included in this 200 limit. And suppose if an employee was serving the company and now he is no more an employee, but in the past when he became a member he was an employee, then also he will continue to be excluded from this 200 limit. Next, for a private company is right to transfer shares restricted. So shares are not freely transferable in a private company. So there is a proper procedure which needs to be complied. In articles of association, there is a restriction that shares are not freely transferable. Prohibition on invitation to subscribe to securities of the company. So private company cannot invite general public. It cannot advertise general public to come and subscribe in the securities of a private company. It cannot advertise to the general public. This is invitation to subscribe is prohibited for a private company. If it wants to do the same, then it will have to first convert to public company. Small company is a private company. Okay, a small company, there is a definition of small companies with limit of 40 lakhs that we will go through in a while. But small company is a private company. So Next is OPC. One person company can be formed only as a private company. So by design, one person company is a private company. One person company also falls in the definition of private company. Next, we move to public company. So here we are discussing types of companies based on its members. First, we discuss based on its liabilities, limited, unlimited, guaranteed. Now we are discussing based on its members, one person company, private company, and public company. So private company is one which is not a private company. Articles do not have a restricting clause. There is no restriction as we saw in case of private company. There was restriction on transfer of shares. Shares freely transferable. Shares can be freely transferred. No minimum paid up capital requirement here also. Like erstwhile we had requirement of minimum 1 lakh paid up capital, but now there is no minimum paid up capital requirement. Next is minimum number of members. Now there this is changed. In private company we learned that minimum number of members required was 2 and maximum it can go to 200 excluding employee come shareholders or erstwhile employees come shareholders. But here in case of public company minimum number of members is 7 and maximum number of members is unlimited. There is no limited. There can be as many members as who wish to subscribe to the shares. So it can make a public offer and many people can subscribe to the shares. But minimum requirement is 7. 7 is the minimum required number of members for a public company. Subsidiary of a public company is deemed to be a public company. So if a company is a private company, but it is a subsidiary of a public company, then it will be deemed to be a private company. For a long period of time, I thought that deemed public company need not comply with all the requirements of a public company. But eventually, I found and realized that once a private company is deemed to be a public company, then due to deeming provision, it will require to comply with provisions of public company, applicable, all the provisions applicable to public company. Next is on the basis of control. Okay, so after on the basis of control, next is means types of companies on the basis of access to capital. So other companies, then what are the other companies? So this video, it is already around 18 minutes long. So let's conclude on this video with our basic understanding as available on screen. And next video we will proceed with other types of companies. So far we have covered companies on the basis of liability, companies on the basis of members, and next we will cover companies on the basis of control and on the basis of access to capital. Thank you. Take care.